Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions and remind our internet viewers that they can send their questions or comments at any time, simply emailing us at speaker@heritage.org. We, of course, will post the program on the Heritage homepage for everyone's future reference following today's presentations. And as noted in the lobby, since this is a book program, we do have copies of The Grasping Hand available for purchase and signing by our author. Hosting our discussion is Paul Larkin, who is Senior Legal Research Fellow in the Edwin Meese Center for Legal and Judicial Studies. He directs our Overcriminalization Project to counter abuse of the criminal law, particularly at the federal level. From 1984 to 93, he served at the Department of Justice as an assistant to the Solicitor General as an attorney in the Criminal Division section on organized crime and racketeering. He also has experience serving as counsel to the Senate Judiciary Committee, has worked at the EPA, as well as Assistant General Counsel for Verizon Communications. Please join me in welcoming Paul Larkin. Paul?
Thank you very much for taking the time out of your day to come here to listen to our expert speaker. We have all heard the aphorism attributed to a Roman general and statesman, Pliny the Elder, that home is where the heart is. Lawyers are familiar with James Otis's challenge to the writs of assistance, where he said, "A man's house is his castle." Some of us know that Laura Ingalls Wilder once said, "Home is the nicest word that there is." And Oliver Wendell Holmes, a justice of the Supreme Court, once said, "Where we love is home. Home that our feet may leave, but not our hearts." Unfortunately for Suzette Kelo and some of her neighbors in New London, Connecticut, none of those four people sat on the Supreme Court 10 years ago when the court decided the case of Kelo versus City of New London. The facts in Kelo, in brief, were these. Officials at Pfizer, a multinational pharmaceuticals company, and the governing officials in New London, Connecticut, worked together to obtain local property so that Pfizer could establish a headquarters there. Unfortunately, the development plan that they came up with required that residents in the Fort Trumbull neighborhood of New London be ejected from their property. Most of the affected residents declined to fight the city's plan, but a few did. The fighters, such as Suzette Kelo, argued that the city's use of eminent domain violated the Fifth Amendment, which states in part that, quote, "nor shall private property be taken for public use without just compensation." Their argument was straightforward. Taking land from A and giving it to B was an archetypical example of a purely private taking, and therefore was not a taking for a public use. The case made its way to the Supreme Court, which ruled against the homeowners by a 5-4 vote. In ruling that the taking and giving property from A to B was for a public use, the majority opinion stretched credulity almost as much as one of Hillary Clinton's explanations for her lost emails. Eschewing all concern for the hallowed place a home occupies in Anglo-American jurisprudence, 5 justices essentially ruled that the government may take a home from one person and give it to someone else, as long as the government can argue in court without bursting into laughter that the community will be better off in some mysterious way with the homeowner's house in different hands. If that result seems troubling to you, you are not alone. Most of America felt that way. State legislatures and courts across the nation responded with alacrity to the ruling. They treated the majority decision as if it were some type of loathsome disease and adopted some types of protections against eminent domain for homeowners. Having been publicly spanked for its ruling in Kelo, the Supreme Court has shied away from the issue ever since. Today, we will hear about the Kelo case from Professor Ilya Somin, the author of a very scholarly book about the decision, the public's reaction to it, and whether that reaction will actually prevent the disease from reoccurring. Professor Somin is a professor of law at the George Mason Law School. He obtained his undergraduate degree from Amherst College, a graduate degree from Harvard University, and a law degree from the Yale Law School. His research and scholarship focuses on constitutional law, property law, and the political process. He has penned numerous articles in journals such as the Stanford Law Review, the Georgetown Law Journal, and the Yale Law Journal. He has also written another book, Democracy and Political Ignorance: Why Smaller Government is Smarter, and is a co-author of the book known as A Conspiracy Against Obamacare, The Volokh Conspiracy and Healthcare Case. From 2006 to 2013, he was the editor of the Supreme Court Economic Review. He writes regularly for the popular Volokh Conspiracy blog, and his opinion articles have appeared in the Wall Street Journal, the New York Times, USA Today, Legal Times, and the National Law Journal. Once described by Professor Richard Epstein as, quote, a national treasure, Professor Soman will share with us his analysis of the Supreme Court's decision in Kelo. Please join me in welcoming him to this event.
Make sure this works. Yes, it does. So I'd like to start by thanking Heritage and Paul for organizing this event and all of you for coming. I'd also like to thank the Supreme Court for deciding the Kelo decision, because although I think they got it badly wrong, it was really good for people like me who study this area. I was able to get multiple articles out of it. It helped me get tenure, and now I've been able to publish a book. So to the extent the Supreme Court listens to me, which they rarely do, I urge them to keep up the bad work, because it's really good for those of us who write in this area. It's a great way for us to advance our careers, even though it's bad for the public interest when they do this sort of thing. So in this presentation, I'm going to start off by talking about the Kelo decision itself, how it originated, and how it got to the Supreme Court. Then I'll discuss why the Supreme Court was wrong in what it did, both from a standpoint of originalism and also living constitutionalism. Further, I'll talk a little about the effects of the sorts of takings that were upheld in the Kelo case on the ground. Although the purpose of this taking was to promote economic development, such condemnations actually tend to cause more harm than good, often even just from a standpoint of development itself. They tend to destroy more economic value than they create. Now, some scholars have argued, yes, there are abuses in this area, but we can fix them through a variety of different kinds of partial reforms without actually banning these sorts of takings completely. I'm going to suggest that while some of these partial reforms have merit, they're not as good as simply completely banning economic development and blight condemnations. Finally, we'll take a look at the massive and in many ways unprecedented political and judicial reaction that Kelo generated, and we'll see that while that reaction definitely improved the situation compared to what it was before, it didn't solve the problem as fully as may have seemed at first sight. So first things first, how did this taking even originate in the first place? As Paul mentioned, it arose in the city of New London, where the city authorities, in cooperation with Pfizer Inc., hoped to revitalize a economically somewhat depressed neighborhood. In order to carry out their project, they thought they needed to acquire over 90 residential properties. While most of the owners sold out, quote unquote, voluntarily, though actually under the threat of eminent domain and various forms of extra-legal harassment, a total of 7 owners who between them owned 15 residential properties chose to fight this in court on the grounds that Paul mentioned in his introduction, and the case made its way up to the Connecticut Supreme Court, which upheld it in a close 4-3 decision. Then, to the surprise of most experts, myself included, the case ended up in the federal Supreme Court. We were surprised because the Supreme Court had already said in the Berman versus Parker case and other cases since the 1950s that a public use can already be almost anything that the government says that it is. So most people thought, well, this issue is settled. It's very unlikely that the court would revisit it. But they did, in fact, revisit it, And ultimately, they still upheld a very broad view of public use. They ruled that a public use could be virtually anything that benefits the public in some way, even potentially, and even that the government is not even required to prove that the supposed public benefit, in this case economic development, will ever actually materialize. So that part perhaps was not too surprising to observers because it was fairly consistent with previous precedent. However, what was surprising was the decision was a very close 5-4 ruling. There were strong dissents by Justice Sandra Day O'Connor and also by Justice Clarence Thomas. So the first immediate effect of the Kelo decision was to break up what it seemed like a strong pre-existing consensus that a public use is pretty much anything the government might want it to be. Before Kelo, people like me who favored a narrow definition of public use, they could easily be dismissed either as weird ideological extremists or as ignoramuses who really don't know anything about constitutional law. After Kelo, you couldn't say that anymore. If Justice O'Connor, who epitomized moderation on the Supreme Court, was on your side, then your position could no longer be dismissed as being weird or out of the mainstream. It might not predominate, but it's certainly the result of Kelo was to make such a position respectable and to destroy the seeming consensus that had existed before in this field. Before moving on to the broader issues addressed in the Kelo case, it's worth focusing on what happened on the ground in the case and what the result in New London actually was. This is Suzette Kelo's famous Little Pink House, which was one of the properties condemned and became a nationally known symbol of the case. This is what the same property looks like today. As you can see, not a lot of economic development has taken place. That's because the development project here was flawed from the get-go. It was in trouble even before the Supreme Court ruled on the case, and 10 years later, still nothing has been built. Indeed, as you can see, they haven't even fully cleared away the rubble from the foundations of Suzette Kelo's house. However, it would be a mistake to say that nobody has benefited from the Kelo condemnations because a colony of feral cats have taken up residence on the property. They are the only regular users, and the only economic development so far is that some people have built some probably illegal feral cat shelters, some improvised shelters so that the cats can take refuge from the elements when they get bad, particularly in the winter. So there is now, actually, since my book went to press, there is now a plan that the New London authorities have to use some of the condemned property as a memorial park in honor of victims of eminent domain. When and if that plan comes to fruition, it will be economic development of a sort, but obviously not the type or amount of development that was initially promised here. So I think it's an extreme case when you have a situation like this where nothing was built at all, but as I will suggest later in the presentation, it's actually pretty common for these sorts of taking to destroy more economic value than they create, even if it rarely happens that literally nothing is built. So I'd like to move on now and talk about why it was that the Supreme Court was wrong in its decision here. And since this is the Heritage Foundation, I'll start off with why it's wrong from the standpoint of originalism. The debate over public use and its meaning is not a new one. Almost right from the beginning, when the Bill of Rights first was enacted and included the public use clause of the Fifth Amendment, there's been a conflict between two views of public use. One, which I call the broad view, is similar to what the Supreme Court adopted in Kelo in previous cases like Berman versus Parker. It holds that a public use is simply anything that might potentially benefit the public in some way, regardless of whether the new owner of the property is a private entity or a public one. But there is also the narrow view, which holds that a taking is only for a public use if the condemnation is for a publicly owned project, such as a road or a bridge or infrastructure project, or if it's going to be a new private owner, it must be one that has a legal obligation to serve the entire public. For example, a public utility of some sort or the like. And there has never been a complete consensus in favor of either one of these views, but if you look back in the 1790s, in the period around the time when the Fifth Amendment was first adopted, the narrow view seems to clearly predominate. Many of the founding fathers and also other jurists and experts of this era, they believed that natural rights, a natural right to property, precluded takings that simply transfer property from A and give it to B. This famous phraseology actually dates back to this period, and leading legal authorities and treatises of this era, they made that assumption and therefore assumed that you couldn't have a true public use if the new owner of the condemned property was simply an ordinary private owner or an ordinary private business. Now, many originalists today argue that when we applied the Bill of Rights against the states, that we should look not to the original meaning as of 1791, but rather the original meaning as of 1868, when the 14th Amendment first made the Bill of Rights applicable against state and local governments. Before that, the dominant view was that it only constrained the federal government. And by 1868, we have actually a lot more evidence of the original meaning of public use than we do even for the 1790s, because by that time, numerous state Supreme Courts had already interpreted the meaning of public use under their state constitutions. Then as now, almost every state constitution contained a public use provision that was identical to or very similarly worded to the federal one. And while there was disagreement among the state courts, a large majority by the 1860s and 70s had ruled in favor of the narrow approach to public use, and the same thing was true of leading legal treatises of this era, all or most of which also came down in favor of a narrow view of public use. In the 1860s, obviously, people didn't have Westlaw or Lexis or the internet, so they were much more reliant on legal treatises to tell them what the meaning of legal terms were, and they were much more influential in influencing both expert and to some extent even public opinion in that era than they might be today. And in the book, I also review other evidence of the original meaning of public use, both in the 1790s and in the 1860s. And while that evidence is not completely one-sided, the large preponderance of it does clearly support the narrow approach to public use and not the broad one. Now, obviously, not everybody is a constitutional originalist. Many people, even if not many at the Heritage Foundation, are living constitutionalists and believe that the interpretation of the Constitution can reasonably change for various reasons over time. In the book, I discuss the Kelo case from a standpoint of several leading versions of living constitution theory and argue that most of them also come down against the Supreme Court's decision. Here I'll just briefly mention perhaps the most popular of those theories, the idea of representation reinforcement, the theory associated with the famous legal scholar John Hart Ely, who argued that what we should be doing with judicial review is protecting those people who cannot protect themselves in the political process, the so-called discrete and insular minorities the Supreme Court famously referred to in the Caroline Products case. If this is your approach to judicial review, then it turns out that Kelo was a terrible decision, because by and large, the people who tend to be victimized by these takings are poor, politically weak, often racial minorities, whereas those who benefit, in this case perhaps the Pfizer Corporation, they tend to be influential and powerful. In other cases, it's people like Donald Trump, who has several times instigated takings of this sort. It's no accident that what you tend to have is someone like Trump using this to take property away, in one case from an elderly widow. There are not a lot of cases where elderly widows can successfully lobby the government to condemn Trump's property and transfer it to themselves. So it's a classic case of the victimization of the politically weak by those with greater influence. Indeed, in one respect, those victimized by these sorts of takings are in even worse position politically than the sorts of groups typically associated with the representation reinforcement theory, because in most cases, at least the people who suffer are able at the next election to vote against the government officials who approve whatever policy it is that is oppressing them. But if your property is condemned and you lose your home or your business and you end up being forced out of the community entirely, often you may not even be around at the next election to vote against the people who did this to you. So in that respect, you're even worse off than are some of the other groups that are typically considered when we analyze representation reinforcement theory. In the book, I also discuss several other versions of living constitution theory, and I'm happy to talk about them in the questions. But for now, I'd like to mention a couple of other flaws in the Kelo majority, which I think should trouble you regardless of whether you're an originalist, a living constitutionalist, or perhaps some combination of the two. One big flaw is that there's a deep internal contradiction at the heart of the majority's reasoning. On the one hand, they say you have an individual right not to have your property condemned for something that isn't a public use. That right is in the Constitution to protect you from abusive behavior by the government, particularly state and local government. But then they say, well, who gets to define the scope of that right? Well, it's actually the legislature, the government, the very entity that this right is supposed to protect you against in the first place. This doesn't really make a lot of sense. There is no other part of the Bill of Rights which the Supreme Court interprets in this way, deferring on the meaning of the right to the very government entities that the right is supposed to protect you against. It's kind of like saying we have a problem with chickens being stolen from chicken coops, so we need to appoint a group to make some rules determining who will get access to chicken coops and on what terms, and who will we appoint to do that? Well, it'll be a committee of wolves. Now, obviously, if you appoint the wolves to guard the chicken coops, the chickens will get stolen and eaten, and that's pretty much what has happened with the Supreme Court's doctrine in this particular area. Now, there's also another important flaw in the majority opinion. In a famous passage of that opinion, Justice John Paul Stevens writes that the broad view of public use is supported by, as he puts it, a century of precedent. Now, I do recognize, I mentioned before, that the broad view of public use was endorsed by the Supreme Court in Berman versus Parker in 1954. But when Stevens refers to a century of precedent, he's citing cases from the 1890s and early 1900s that actually were not public use precedents at all. Rather, they were cases where people were challenging state takings in federal court using the Due Process Clause of the 14th Amendment, the so-called substantive due process doctrine of the Lochner era. And under that doctrine, the court indeed was deferential to state and local governments, not as deferential as it later was in cases like Berman and Kelo, but fairly deferential. But they also made clear that in cases that actually involved the public use clause, there would be a less deferential standard, particularly when it comes to takings that transfer property to private parties. You might ask, why were people during this period using the Due Process Clause to challenge takings when they really should have been using the Public Use Clause? The answer is that during this era, the Supreme Court had not yet recognized that the 14th Amendment had incorporated the 5th Amendment and other parts of the Bill of Rights against state governments. Therefore, if you wanted to challenge a state taking in federal court, the Due Process Clause was the only pathway open to you. So whatever you think of those Lochner-era cases, they were not actually public use cases, and therefore were not cases that were legitimately citable as precedent in Kelo. Now, to his credit, Justice Stevens, in a speech that he made after he retired from the court, he has actually admitted that he made a mistake on this. He calls it an embarrassing to acknowledge error. There are not many major Supreme Court decisions where even the author of the majority opinion has ended up admitting that his analysis was based in part on a serious mistake. Though I should note that Stevens still thinks that he got the bottom line correct in that decision, just on the basis of reasoning very different from what is actually written in the opinion, and also reasoning that, as we can discuss in questions if you're interested, his new reasoning really would go against not just one century of precedent, but actually more than 2 centuries of it. So his new reasoning avoids the problem that's in his opinion for the court, but would, if endorsed by the court, create even more serious problems. And in fact, until Stevens endorsed this particular line of argument, it had almost no support either among academic experts or within the judiciary, even among those who otherwise approve of the result in Kelo. So I think there is a strong case against the result in Kelo, whether from the standpoint of originalism or living constitutionalism, or even just from the standpoint of standard jurisprudential reasoning that might cut across different approaches to constitutional theory. In the next part of the talk, I'd like to discuss a little bit the on-the-ground effects of these sorts of takings. And as it turns out, the effects tend to be very harmful and dangerous. One of the big problems with economic development condemnations like the one upheld in the Kelo case is that they open up all sorts of opportunities for influential interest groups to capture the political process and use it to benefit themselves at the expense of the poor and the politically weak. If you allow the government to take property for economic development, and then you don't even require them to prove that the promised development is ever actually going to materialize, that means that almost any politically influential business can say, if we take this person's property and give it to us, we might produce some more development or tax revenue in the long run, even though studies show that on a systematic basis that rarely, if ever, happens. And so you create almost a free-for-all where the politically influential businesses and other interests can use this for their advantage. Now, you might say that this will be controlled by the political process. If the voters see that there are these abusive takings going on, ones that don't really produce any net economic benefit, they can vote out the bastards who did this at the poll and then elect a new set of bastards who hopefully will avoid doing similar problems. But in reality, the monitoring of these sorts of takings by the voters is generally very weak. As I discuss in my other book, Democracy and Political Ignorance, often the voters pay very little attention to the details of government policy. They often don't know even very basic facts, and they particularly have trouble figuring out what is going on with relatively complex policies that are hard to assess, such as these sorts of takings projects. Moreover, often the actual results of one of these takings are not evident until several years after it has occurred, and by that time, public attention will usually have moved on to other issues. Very few elections turn on the results of takings that were completed 5 or 10 years ago. That very rarely happens, and therefore, the monitoring of these projects by voters tends to be, in most cases, quite weak. Now, I do acknowledge that there is a possible serious economic rationale for these takings. This is the so-called holdout problem. Imagine that you have a genuinely valuable project, unlike the one in the Kelo case, that will generate, say, $1 million of extra economic development over and on top of what existed there before. But imagine also that you must acquire this property from 100 different owners. You got to assemble all of it to make your project work. So you go to the first person and you say, well, I want to buy out your property for my wonderful development project that will create $1 million of additional revenue. And they say, I'd be love to sell to you, but I can't bear to part with it for less than $950,000. That'll still leave $50,000 of profit for you. Now, if you concede this demand, other owners will make similar ones, and pretty quickly, either you have to abandon the project or you end up paying more for it than it is actually worth. And so this is the argument used by advocates of these sorts of takings. They fear that unless you can use eminent domain, you will end up having a problem with the situation where there will be these holdouts that will occur. And I think there is something to the argument, but it is not nearly as compelling as it may seem at first sight. And this is so for several reasons. One is that in reality, there's little reason to expect that these kinds of takings will be driven by genuine holdout problems as opposed to the relative political power of the people on each side. Therefore, the powerful will be able to use this to condemn the weak. Secondly, modern building techniques often make it possible to build around holdouts. There are many books you can look at with pictures of architectural holdouts, projects that were still built even though some 1 or 2 owners refused to sell. These are sometimes used as justifications for the use of eminent domain, but what they actually show is the opposite, that you could build these projects without actually having to take every square inch of land. Finally, even in cases where there's a genuine situation where you really do need every square inch of land, often the private sector has effective mechanisms for dealing with the situation without resorting to eminent domain. There are several possible strategies, but the most common one is secret assembly, where the developers send agents to buy up the property without necessarily telling people what the purchase is for, and this prevents them from even knowing that there's an opportunity to be a strategic holdout. And you might say this will never work, the news will leak out, but in reality, history shows that it often does systematically work. For example, this is how Disney acquired the property that they needed to build Disney World. And obviously, if this works for a developer like Disney, that is very much covered by the media and is in the public eye, works even better for less high-profile developers of the sort that do most projects. I don't claim that these methods will work in every single case. I don't claim that if you adopt the approach to advocate here, you have a free lunch that will never have any costs and never block any valuable projects. But I do think that the harmful projects that are blocked will be far more common than the beneficial ones. And so while it's not a free lunch, it is a lunch that is well worth the cost of acquiring and eating it. Before going on, I'd like to also talk a bit about blight condemnations, which are distinct from economic development takings but closely related to them. Indeed, it was a blight takings case in 1954 in the Berman case where the Supreme Court first endorsed a very broad definition of public use. Blight condemnations differ from economic development takings in the sense that with a blight condemnation, before you can take the property and give it to a private owner, you have to first show that it is blighted. And so you might say, well, who can be in favor of blight? Why wouldn't you want to condemn property that suffers from these terrible conditions? There are not a lot of people who say we need more blight rather than less. However, blight condemnations in the real world have two kinds of very serious problems. First of all, in many states, blight is defined so broadly that almost any area can be declared blighted and condemned. So even such places as downtown Las Vegas and Times Square in New York have, by these sorts of rules, been declared blighted, and therefore property has been condemned for a transfer to influential private interests. Second, even in areas where there is genuine blight, as a layperson would define the concept, it doesn't follow that the best way to save the blighted community is to first condemn and destroy it. There are better and more humane ways to alleviate blight than to condemn and forcibly displace people, because when you do engage in forcible displacement, it tends to harm large numbers of innocent people, many of them poor and badly off. Indeed, since blight takings first became common in the 1940s and 50s, we have forcibly displaced some several million people by them, most of them poor and minorities, even though research on economic development shows that one of the best ways to assure it in the long run is to actually respect the security of property rights. When American foreign aid experts give advice to underdeveloped countries on how to grow their economies, one of the pieces of advice usually given is that they must have secure property rights. That's what incentivizes people to invest and also to form social ties that help promote development. This is good advice, and we should take it in the underdeveloped areas of our own country as well. There are much better ways to alleviate blight and other threats to public health than to simply condemn large numbers of people and force them out. And I can talk more about that in the questions if people are interested. So at this point, I think we've shown that there are serious problems with these sorts of takings, but many scholars argue that we don't necessarily need to ban them. We can have more limited reforms that would address this problem without forbidding states and local governments to engage in beneficial takings. Here, I'll just talk about two of the most popular of these reforms. In the book, I cover many others as well. Perhaps the most commonly advanced one is the theory, well, this is really all about the compensation. If you increase the compensation for these sorts of takings, then if you increase it enough, the people will be just as well off with the compensation money as they would have been if they had kept their property in the first place, and then nobody would be able to complain about anything. Now, I do think that in many cases it is desirable to increase compensation, but I also think that compensation is unlikely to be a sufficient solution for this problem. This is so for a couple of reasons. One is that it turns out to be very difficult to increase compensation in such a way as to properly account for all the different losses. Current Supreme Court precedent says that when your property is condemned, you're supposed to get the fair market value, what the property would sell if you put it up on the market. But obviously, many people value their homes or businesses or other properties at levels above the fair market value. They have what economists call subjective value. If they didn't, they probably wouldn't have waited for their property to be condemned. They might well have sold it even before. But when you try to estimate subjective value, it turns out to be extremely difficult. And to make a long story short, it's very hard for the government to figure out a formula for doing it. So you will tend to either undercompensate people most of the time or overcompensate. And overcompensation is also problematic because if you start having it, then people actually have an incentives to lobby to have their property taken by eminent domain. Another problem with increasing compensation is that while increasing compensation, if you do enough of it, that may solve the issues of the immediate victims of eminent domain. It doesn't solve the other problem of harmful takings, which is the harm done to the community as a whole when you have worthwhile land uses replaced by ones of lower value. Indeed, the harm to the taxpayers and the community is actually exacerbated when you increase compensation because, of course, they now have to pay more money for these projects. So in that respect, increasing compensation in some cases can actually make things worse rather than better. Another popular reform, one hinted at in Paul Larkin's introductory comments, is the idea that, well, what this is really about is protecting homes. We can understand if people feel bad if their homes are taken, we might want to prevent that, but if it's just commercial property or some other kind of property, then we can let the takings go forward, and it's really not so bad. I totally agree that it's very important to protect homes, but I think it's also important to protect other kinds of land uses as well. Often small business property or charitable property, such as that of churches and schools and the like, often also has very high subjective value for people, and therefore it's important to protect it. And even if it's purely commercial property, it doesn't follow that we want to displace it by eminent domain and end up with what will often be a lower value project rather than a higher value. So while I agree to protecting homes against these sorts of takings is much better than simply having open season on all properties, it would be even better to protect property regardless of whether it is a home or whether it is being used for some other purpose. In the last part of the presentation, I'd like to briefly talk about the dramatic political reaction that was generated by the Kelo case, which in many ways was unprecedented. Most Supreme Court cases draw very little reaction from anybody, only experts pay attention to them, but this one was very different. Surveys showed that 80% of the public disapproved of the result in Kelo, and that this cut across ordinary ideological, partisan, and other lines that divide people. This was a rare instance where the NAACP, Rush Limbaugh, and even Bernie Sanders were all on the same side. That doesn't happen very often, but it happened here. And in the aftermath of this, some 45 states enacted eminent domain reform laws, which sought to constrain these sorts of takings. And this is a record. No other Supreme Court decision in all of American history generated as much state legislation in response as this one did. And I think there was enormous progress in many states, but people who concluded as a result of this that the problem has been solved and therefore we don't need judicial protection of this right, I think that conclusion turns out to be premature, because if you look at the laws, as I do in some detail in the book, many of them, a slight majority in fact, turn out to be ineffective in the sense that they give property owners virtually no new protection against these sorts of takings. This is particularly true of laws passed through the ordinary legislative process, where in 22 out of 37 cases, they tended to be ineffective. And you might ask, well, how did this come about? The most common scenario is that the law says you can't take property from one private individual and give it to another if it is for economic development, but you can do so if the property is blighted. And then, as I suggested before, often blight is defined so broadly that virtually any property will qualify. So this raises three interesting questions. One, why was there such a big backlash, given that, as I said previously, Kelo wasn't a major change from previous precedent, so people were angry about these takings after Kelo. Why were they not angry before? Secondly, given the amount of public anger, why did so many state legislatures enact weak and relatively ineffective laws? And finally, how do we explain the pattern of laws that were adopted? As it turns out, laws adopted by citizen-initiated referendum tended to be much stronger than those enacted by other means. And I think there are several factors that account for these three phenomena, but a big one is the problem of political ignorance. I was able to collect survey data which showed that 87% of the public either did not know whether their state had passed a post-Kelo reform or did not know whether the reform in their state was likely to be effective or not. And indeed, even this data probably overstates the true level of knowledge because some people likely got the right answers by guessing. Often people will guess rather than admit to a pollster they don't know something because they've taken standardized tests where they're told to guess rather than leave a question blank, and they follow that strategy on public opinion surveys as well. So I think this helps explain why there was such a big backlash in the first place. Before Kelo, most people simply weren't aware that these sorts of takings were going on. Experts knew about it, but most people are not eminent domain experts. It also helps explain why there were so many ineffective reforms. While people, as a result of this highly publicized case, became aware of the problem, that didn't mean that they were going to closely monitor the details of post-Kelo reform legislation, and in fact, most of them did not. And finally, I think this helps explain why referendum initiatives tended to be more effective. It's not because people are better informed when they vote in referenda, when they vote in regular elections. It's because of the different incentives of those who draft these laws. When you have ordinary legislation, the legislators have an incentive to take advantage of political ignorance and quiesce public opinion to some degree with a law that might be ineffective but looks like it's doing something. But on the other hand, they want to avoid riling up the Donald Trumps and others who benefit from these sorts of condemnations and tend to pay closer attention to what is going on with the legislation. When, on the other hand, you have referendum initiatives, those tend to be drafted by property rights advocates who don't have an incentive to run for election and re-election and don't particularly want to propitiate influential interest groups. There is one exception to the pattern of strong referendum initiatives, but it is one that actually proves the rule. It is Proposition 99 in California, which was put on the ballot by the California League of Cities, an organization of local governments, the very entities that exercise the power of eminent domain. So understandably, they didn't want their own powers to be limited. You might ask, why did they even bother to put this initiative on the ballot in the first place? It's because on the ballot at the same time was Proposition 98, drafted by property rights advocates, that really would have limited eminent domain significantly, and Prop 99 even includes a provision that would have negated Proposition 98 if the two of them had been enacted at the same time. So Prop 99 was a kind of Trojan horse. As it turned out, Prop 98 was defeated in its own right because it included other stuff that was less popular than eminent domain reform, but the CLC could not know ahead of time that that would happen, so they decided it's better to be safe than to be sorry. So overall, great progress has been made as a result of post-Kelo eminent domain reform, just not as much progress as it looks like. I should also add that some important progress has been made in state Supreme Courts. Several state Supreme Courts since Kelo have considered the question of whether Kelo's interpretation of the federal public use clause should govern their own interpretations of their state clauses. And unlike in the case of Berman versus Parker in the 50s, which was quickly adopted by numerous state Supreme Courts, since Kelo, that ruling has been repudiated by several state Supreme Courts who have all ruled that economic development takings are forbidden by their state constitutions. This further underscores that since Kelo, we no longer have a consensus in this area. There is some movement against the broad interpretation of public use. So I think in the long run, there is a good chance that Kelo will be either overruled or at least limited by the Supreme Court. And at the very least, there has been important progress in this debate, but there is still a lot of work left to do. I end with this. This is Willow the Golden Retriever making the case for property rights. It would be a shame if she were to lose her home for transfer to feral cats. And on that note, I conclude, but I very much look forward to your questions. Thank you. Should I step on the podium? Or?
No, you can stay there. Let me say, we'll now take questions from the floor. Please do two things. First, identify yourself so we know who you are. And then second, ask a question and keep it short. Yes, sir.
Hi there, David and Sarah from the Heritage Foundation. I just got a question. You practice or you teach at George Mason. I live in Virginia. There was a proposition on the ballot there, referendum back in 2012. Does that fit in the ineffective or effective category of referendums that you were talking about before?
The Referendum enacted in 2012 in Virginia actually is a pretty strong one. It's not perfect, but what it does is it forbids takings for economic development to transfer to private parties, and it also, in conjunction with other laws, strictly limits blight takings to cases of genuine blight. It also has some other beneficial elements, such as increasing compensation in some cases. So while it's not a perfect reform, it still does allow traditional blight takings where the property really is blighted, which I think is problematic. It's certainly a big improvement over the status quo. I should add also that even before this referendum question, Virginia had enacted some pretty good reforms by ordinary legislation, but what the referendum did is enshrine those in the state constitution, making them harder to reverse.
Sir, there's a microphone right there.
Hi, I'm Chris Prodzik. I'm a realtor in Northern Virginia. And can you just speak to what kind of influence have these instances where like a sports stadium that is tax funded had on the occurrences of people losing their homes and so forth? Can you comment on that a little bit?
So takings for professional sports stadiums are among the worst of these sorts of takings. I say that even though I'm a big sports fan. If you look at studies by economists across the political spectrum, they all pretty uniformly show that public subsidies for sports stadiums, whether through eminent domain or something else, have virtually no net economic payoff for the community. Often they have a net cost. And we also know that the major professional sports leagues certainly have enough wealth that they can fund their own stadiums. Indeed, up through the 1950s, virtually all sports stadiums built in the United States were built without either eminent domain or government funding, even though obviously the profits from professional sports in that era were less because we didn't have nearly as much in the way of television and cable and the like, and it was a much poorer society. Takings for sports stadiums are, in many ways, a terrible idea, and they're actually almost a poster boy, if you like, for the kind of thing that should be banned.
Let me ask a question. To what extent does the just compensation formula assume that a taking will only be for public use? And if you don't, therefore, take it for use by the government or by the public, or as in the case of a utility, by a private party for the benefit of everyone, are you in that way undercutting what the just compensation formula was designed to deal with?
I'm not sure I fully understand the question, because the compensation formula would be the same regardless of what the taking is for, so long as the taking is constitutional in the first place. So I wonder if you could clarify.
Sure. If the government could only take land for use as a government office building or as a road, even the person that lost the property would get some benefit from it, from the government acting in a more efficient manner or providing services locally, or a road increasing commerce and transportation so that they get some economic benefit from how it's used. But if all you do is take it from A and give it to B, the person who lost the property is not going to get that offsetting benefit.
Yeah, I see what you mean, but I'm not sure that ends up being a very powerful distinction, because it could be that even a taking for a narrow public use can still be economically flawed and efficient. In Chapter 8 of the book, I discuss how that can happen. And contrary-wise, a taking for a broad public use, at least in theory, in some cases, could potentially provide economic benefits to community. So I don't think that the justification for a narrow doctrine of public use is necessarily that the owner inevitably and always benefits. Still, I do think on average there is better economic as well as legal justifications for narrow public use takings, among other things, whereas with takings for private businesses, often you can use secret assembly if it's really a genuinely valuable project. We would not want the government to act in secret to acquire property because we would want open public debate about the use of government funds. And even if we would want the government to act in secret, often they've shown that they can't do so without leaking information. They can't even keep national security information secret, as the WikiLeaks scandal has shown. So it's unlikely that they would be able to keep eminent domain or property acquisition secrets very well.
Oh, back there? Yeah. And then Andrew, then you're next.
Hi, I'm Scott Nilsson. I did my first year at George Mason, then transferred to Georgetown. So I'm a law
Sorry to lose
student,
you.
so sorry to transfer. But I have a question about takings for public use, specifically under the Lucas v. South Carolina Coastal Council, that Supreme Court decision where Justice Scalia said that if there's a total taking by the government, then compensation is due. But if there's a partial taking, that's okay. So the Supreme Court held that compensation is not required when the restriction inheres in the title itself, as part of background principles of the state's law of property and nuisance. And so then going forward, state courts needed to look at those background principles of property law and nuisance in determining whether whether a taking had occurred. So I guess my question is, do you feel like even for public use takings, courts are allowed to have too much discretion in determining whether a total taking has occurred or not?
I think the Lucas case and other similar instances deal with a different issue from the Kelo case. And in Lucas, the issue is not whether the taking was for a public use, it's whether a taking had occurred at all in the first place. Because it's dealing with situations where instead of the government coming along and saying, we're going to use eminent domain to take over your property, what they're doing is just restricting your use of it in some way, but not taking title for the government. And the question is whether the regulation that the government is imposing on you is going so far that it amounts to a taking. And to make a long story short, I do think the current doctrine is too permissive in that regard. They allow too many regulations to go forward without being considered takings and therefore without requiring compensation. But that's a separate issue from the question of public use, because the question of public use only arises at all if you first determine that a taking has in fact occurred.
Andrew.
Hi, Andrew Cluster with the Heritage Foundation. So first, quick, very, very brief comment. You know, with respect to sports stadiums, as with so many problems in America, it goes back to Walter O'Malley. But my question is, with respect to partial fixes, what's to stop, and this is not my area, so what's to stop a locale from perhaps retaining or allowing the original property owner to retain some sort of interest so that if property is not developed, title transfers back or something like that? What's to stop sort of conditional condemnation, partial condemnations or that sort of thing from helping at all with this?
Yeah, so you could, are you suggesting that a reform would require the locality to do that? So I think that might be an improvement. It's not one I consider very much in the book. However, there are several potential problems. One is how realistic would this right be if the purpose is simply economic development and the new owner isn't even required to ensure that a certain amount of development is actually produced, then any sort of reversionary interest to the original owner, would be mostly theoretical. Even if it was somewhat stronger, if you're in effect forced out of your property, particularly if it's a home, but then you say, well, maybe 5 or 10 years from now I can move back, that's not so great, especially since you wouldn't know ahead of time whether you actually could or not. Finally, I think it's questionable whether state and local governments would actually have incentives to adopt a reform like that, particularly for the benefit of those with little political influence. There are some other sort of practical problems as well, but I think those are the more significant ones. I wouldn't rule out the possibility that this might be a good idea in some cases, but I'm very skeptical that it would be more than a very partial solution.
Let me ask one more question. To what extent is the difficulty that we have in this regard, the fact that almost anything can be a public use, due to the fact that in this case, unlike any place else in the Bill of Rights, you get money when the government takes something from you. I mean, the government doesn't pay you if it restricts your First Amendment privileges in some way. It doesn't pay you if they search your home. You think that the justices have basically said that the just compensation clause is the real protection here, and they just have sort of written off the public use requirement because people are getting money as the result of whatever the government does?
Some people do argue that. I think it's questionable whether that is the real reason why we ended up with a doctrine where public use is almost meaningless. Because if that were the reason, you would think that this argument would have been advanced from the beginning. It would have prevailed long ago in the 19th century. But the broad view of public use didn't become the dominant view until well into the 20th century. And as I discuss in the book, the dominant cause of that was not that people suddenly discovered, well, you get compensated. Rather, it was a general bias against constitutional property rights, which was at its height in the New Deal era and immediately afterwards, and has gradually receded over the last several decades. But the idea was not that this isn't important because you get compensated. It was this isn't important because property rights generally are not all that important, and also they involve complex issues of economic policy, which are better left to expert government planners. You see an echo of this even in Justice Stevens' majority opinion, where he says, well, we should defer to the government's carefully considered economic development plan. He even says, well, if there wasn't careful planning, if there was a quote-unquote one-to-one taking, maybe we shouldn't have as much deference. But when there is sort of this planning process going on, that's sort of complex stuff that the court should leave to the experts. So I think it's factors like that that are by far the main reason why we ended up with such a weak public use doctrine. The existence of compensation, I think, was at most a secondary factor, at least in the court's calculations.
Well, if there are no more questions, let me, on behalf of everyone here, thank you very much for coming and encourage you to get a copy of the professor's book. We have them outside, and he'd be glad to sign them. I have read it. It's a terrific book. It goes through the case in detail, the doctrine in detail, the responses in detail, and analyzes whether those responses are good, weak, make the world a better or a worse place. So please, join me in thanking Professor Ilya Soman for coming today.